Hello, everyone. My name is Marcy Koski, and I am a partner and leader of the Husch Blackwell Consumer Financial Services team. Husch Blackwell is a full-service law firm with offices across the country and 800+ lawyers. Our consumer financial services team is also full service. We have regulatory compliance attorneys and litigators across our footprint with deep and specialized expertise and knowledge of the consumer financial services space. We are very excited to have you join us today to talk about some of our favorite topics. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all of your questions today, but if we cannot, it will be answered later via email. We very much encourage questions so that we can ensure a thorough discussion of issues that are timely and important to you. A PDF of the presentation is available in the program materials folder. Note that this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, please be sure to complete our survey. We use your feedback to plan future programs that are applicable to your needs. That is all for housekeeping items. Let's get started with our program. Today, I am joined by Lauren Capitini, Natalia Cruz, and Lisa Lawless, all attorneys on our Consumer Financial Services team. Lauren is one of our regulatory compliance attorneys who helps our financial services clients align their business goals with federal and state regulations. Natalia is one of our Consumer Financial Services litigators. She defends our clients in court, federal and state, against alleged violations of federal and state consumer credit laws, including the Wisconsin Consumer Act. Lisa Lawless is also a consumer financial services litigator and appellate attorney. Her practice focuses on defending clients against consumer credit litigation in federal and state courts, both individual and putative class claims. Lisa has argued several times in appellate courts with an excellent track record of success. Today, our agenda consists of several items. We'll be discussing the Wisconsin Consumer Act, the Wisconsin Marital Property Act, arbitration agreements and jury waivers, and ending with a topic of notes, security interests, and liens. Okay, so the Wisconsin Consumer Act. The Wisconsin Consumer Act is codified in chapters 421 to 427 of the Wisconsin statutes. It was enacted way back in 1973, and it covers the entire life cycle of a consumer credit transaction to which it applies. More on that later. To others who are familiar with other consumer credit laws in other states, you'll recognize in reviewing and in assessing the Wisconsin Consumer Act that many of our provisions are akin to those other states who have adopted the model or some form of the model UCCC model law. The drafters of the Wisconsin Consumer Act relied heavily on the UCCC model law and also looked to provisions of the National Consumer Law Center model in proposing and finalizing provisions to the Wisconsin Consumer Act. Our now retired colleague Ed Heiser, in fact, served on the drafting committee for the Wisconsin Consumer Act back in the early 70s as a representative of the credit industry. In my hot little hands, I have Ed's version of the UCCC model law that he used on the committee, complete with handwritten annotations from him that are fun and insightful to read. I wrote a law review article on his time and his interpretation in view of the Wisconsin Consumer Act after sitting on that committee. In that law review article, he wrote that, quote, the WCA is probably the most sweeping consumer credit legislation yet enacted in any state. And I'll say, much to Ed's chagrin, plaintiffs, attorneys, and courts often cited that quote against the position that he was taking. So per Ed's very accurate description of the Wisconsin Consumer Act, the Wisconsin Consumer Act is made of several chapters noted here on this slide. So what transactions are subject to the Wisconsin Consumer Act? Transactions subject to the Wisconsin Consumer Act are consumer transactions made by a person for personal, family, or household purposes. The amount financed in the credit transaction must be equal to or less than $25,000, and the consumer credit transaction must have been made in Wisconsin. Critically, as noted, it applies only when the amount financed is $25,000 or less. As you might imagine, back in 1973, when the law was enacted, that covered a lot of consumer credit transactions. Of course, now in 2022, $25,000, if you go to a dealer lot and you try to buy a new vehicle or even a slightly used vehicle, the Wisconsin Consumer Act, by its terms, may not apply to that particular transaction. Unlike other UCCC states, there is no periodic adjustment of that amount finance number baked into the statute. Thus, this means that the legislature would have to open up the law and make that adjustment. We talk about whether the transaction is made in Wisconsin. If it's made, quote unquote, made in Wisconsin, the entire Consumer Act applies to the transaction. What made in Wisconsin means? It means the writing is signed by the consumer received in Wisconsin, or there's an inducement by the creditor outside of Wisconsin to a resident of Wisconsin. Inducement would include solicitation by mail or telephone. That's the wording of the Consumer Act. Presumably, mail would also include email. Question that has arisen for us is whether a targeted ad in someone's Instagram scrolling, for example, would be a solicitation enough to invoke the Wisconsin Consumer Act. Certainly, we think the regulator would think so. Now, transactions made outside of the state of Wisconsin, whether to a Wisconsin resident or a person who subsequently becomes a Wisconsin resident, will still invoke some provisions of the Wisconsin Consumer Act. That is a topic that is largely for servicing and collections, and we will touch on that in a subsequent webinar. So stay tuned. Examples of consumer credit transactions. These are examples that are noted on the DFI's website. Basically, the test is whether the transaction is payable in more than one lump installment, one lump payment, or there's a finance charge. If either of those occurs with the transaction, so if the transaction is payable in 2 or more installments, or there's a finance charge, the Consumer Act applies, subject to the other limitations that we will discuss. This, of course, is different from the applicability of, for example, the Truth in Lending Act, which requires that the transaction be 5 installments or more, or of course have a finance charge associated with it before the act applies. So even if a lender's product can get outside the confines of the Truth in Lending Act, it would still be subject to the WCA if it's payable in installments or there's a finance charge assessed on the transaction. DFI notes that student loans are subject to the Wisconsin Consumer Act. There is a big caveat to that. If a public university or a not-for-profit higher education institution grants credit, our Wisconsin Supreme Court, way back in 1980, ruled that such entities are not merchants under the Wisconsin Consumer Act, and therefore the provision of credit by those institutions is not subject to the Wisconsin Consumer Act. Not noted on here, but very much subject to the Wisconsin Consumer Act are consumer credit sales and consumer leases. So there are some exceptions outside of the more than $25,000 for an amount financed. Other transactions that are not subject to the WCA include first mortgages, business credit, including transactions primarily for an agricultural purpose, although there's a couple exceptions in the Consumer Act to that. And then again, this amount financed threshold.
Hey, Marcy, can I just jump in on this last slide real quick? Good afternoon, everyone. I just wanted to point out one thing that often comes up when we're addressing mortgage transactions that are subject to the WCA or not subject to the WCA is first mortgages or first lien equivalents. So first lien equivalents are also not subject to the WCA, and they would be governed by first lien law, like a first mortgage. And what a first lien equivalent is if you are, the creditor is in position, first lien position, and then also takes a second lien on that same mortgage. So it's truly the equivalent of a first lien. There's no different creditor ahead of you. So just pointing out first mortgages or first lien equivalents, which trips some folks up from time to time.
Yes, excellent point, Lauren. Okay, so assume that you have a transaction that's not subject to the WCA. Well, just a cautionary note that you can opt into the WCA by including references to the WCA statutes in the loan contract. So it's important as a defense mechanism to claim that you violated the WCA, that your loan agreement, if it is used for WCA and non-WCA transactions, that it is very clear when and whether the WCA applies. Or you can have entirely separate forms altogether. Just be sure that your staff and employees are properly trained on when they would use the form or not use the form that is WCA compliant. It's very important on that note to be sure that the form, if it is a WCA transaction, that you're using a WCA compliant form, as we'll talk about in these next few slides. So remember, Ed said the Consumer Act is sweeping, and that's absolutely true. So it governs the entire consumer credit transaction life cycle from beginning to end. And here are a few of the ways that it does so. So the WCA incorporates TILA and then adds some additional disclosures like a notice to customer right above a customer's signature, space for the customer's signature. It's also unique in that it provides a specific definition of default. And that definition does vary depending on the product and lender that you are. So the general rule is that default does not occur until a customer is behind by more than one payment for more than 10 days. So if, for example, a payment due date, it's monthly payments, monthly installments, payment due date is the first of each month. If the customer fails to make a payment on March 1st and then fails to make a payment on April 1st, that customer will not be in default until more than 10 days after that April 1st payment due date. For lenders licensed under 13809 or 13814, for loans that are not secured by a motor vehicle, the definition is slightly different. For those lenders with unsecured credit, default is an amount of one full payment that has remained unpaid for more than 10 days. So if in the example I used, the customer misses the March 1st payment, he or she will be in default if he or she does not make a payment by more than 10 days after that March 1st payment. The creditor does not have to wait until the customer misses the April 1st payment by more than 10 days to declare the customer in default. We recommend, as certainly a best practice, to include these specific definitions of default, whichever one applies to you, as depending on what kind of lender or what kind of product you're offering, in your credit agreement, even if it is a multi-state form. But certainly, at a minimum, you must use that definition of default in your servicing and collections. You cannot vary from that definition of default, or it will get you in hot water under the Consumer Act. The Consumer Act also prohibits bargaining for attorney fees and collection costs. However, our DFI, in response to a consumer plaintiff's attorney seeking DFI's opinion on whether reference to attorney fees qualified by a savings clause is a violation of the Consumer Act, and whether the use of statutory attorney fees and statutory collection fees in a loan agreement is similarly violates the Wisconsin Consumer Act, the DFI responded and sanctioned the use of a savings clause in connection with a bargaining for attorney fees and collections costs. So you agree to pay our attorney fees and collection costs if it's sent to an outside law firm, comma, to the extent permitted by applicable law, or if permitted by applicable law. Similarly, if there's a provision that says you agree to pay statutory attorney fees and statutory collection costs, that too is permitted by the Wisconsin DFI. And there is an interpretive letter out there on DFI's website, so you should go back and definitely take a look at the language that's been expressly sanctioned by DFI. We found it interesting, DFI, in that letter, and Lauren and Lisa and Natalia jump in if you have anything to add or vary, but in that interpretation from DFI, we were surprised that it blessed the use of a savings clause. It did so a little begrudgingly. In the past, DFI has said up and down that it really does not like the use of a savings clause. It doesn't want to force the consumer to go back and try to understand if the law does permit them to agree to that kind of provision. The Wisconsin Consumer Act also addresses the charges that a creditor may contract for. So it has a definition of finance charges. It allows prepaid finance charges. It also addresses delinquency fees and default charges, which are those related or restricted to the disposition of a motor vehicle. You must bargain for these. So it's not authority to charge them without having the customer have agreed to them. So they must be contained in your loan agreement. Our delinquency fee section prohibits charges, an installment from, or a late fee from being assessed against an installment more than once. So for purposes of charging a late fee, you must take we use the current installment rule. You must apply the installment that you received to the current installment due for purposes of determining whether to assess a late fee. You can't take that April 1st payment that you receive and apply it to the March 1st payment that's past due and then charge a late fee. We also have this additional charges section like other UCCC states do. And our additional charges section allows consumer credit insurance to be bargained for and charged, subject to certain disclosures and receiving certain consent. It also allows a creditor to bargain for an NSF fee in very specific circumstances. The DFI takes the position that our additional charges section is the end-all be-all on what fees can be charged. So, for example, it takes the position that a non-bank or non-credit union lender cannot charge a convenience fee. In contrast, it is expressly permitted under its safe harbor authority that a bank or credit union may charge a convenience fee. We disagree with DFI that the additional charges section is the end-all be-all. That additional charges section was enacted during a time we had an interest rate cap, and it was intended to exclude from the calculation of finance charge certain fees. It was not intended to limit the fees that could be charged. I'll note that the restrictions on charges in the additional charges section really pertain to closed end. There's a much broader provision in the additional charges section for open end credit that allows the parties to agree to a much broader set of fees that can be charged. Okay, are you still awake? We have a poll question for you. Does your company enter into credit agreements with an amount financed of $25,000 or less with individual consumers where the proceeds are used for the purpose of personal, family, or household purposes? Or do you primarily enter into credit transactions with an amount financed exceeding $25,000? Or not applicable, you're just here because you heard that our consumer finance team is really fun. So please vote. Okay. All right. So most of you are offering credits that is subject to the Wisconsin Consumer Act. That's why you are at this webinar today. All right. One more poll question. True or false? The WCA can apply where the consumer resides in Wisconsin, but the transaction is consummated outside of Wisconsin. The WCA can apply when the consumer resides in Wisconsin, but the transaction is consummated outside of Wisconsin. True or false? So
this is a trick question, Marcy.
This is a trick question. So the typical scenario would be, or a typical scenario would be, a consumer drives down to Illinois, our great neighbor to the south. They drive to Illinois, and I don't know why they would, but let's say they do. They drive to Illinois and they buy a car and they finance the car. Is the WCA, is that transaction subject to the WCA? Okay. True. 77% of you say true. 22% say false. The answer is actually somewhere in between. So the chapters 421 through 427 in their entirety do not apply to that transaction. Some parts of 421 of the WCA do apply to that transaction. Including well, what does apply would be some limitations on fees, and that depends on how you're enforcing them. It's a complicated, nuanced provision. Also, if you're picking up the vehicle in Wisconsin, Chapter 425, which is the remedies and the notice of right to cure provisions, and the notice regarding self-help provision, that would apply to that transaction, but we'll get into that in a subsequent webinar. Okay, I'm going to pass it off to Lauren.
Awesome. Thanks, Marcy. See, I told you it was tricky. Everybody was right. Well, good afternoon again, everyone. Thank you for joining us. I have the opportunity to talk to you about the Wisconsin Marital Property Act, or the WMPA, or the MPA as we call it. And this could be a whole presentation in and of itself. We could take a full hour or more. So we're just really going to hit the highlights, kind of like Marcy did on the Consumer Act. So let's see, that's me. As you know, please call or email anytime. So let's talk about the Act generally. So marital property is really a form of community property. So you hear about community property states or separate property states. Wisconsin would be one of those that fits in that community property states. We just call it marital property. It's a little bit different flavor to it. The WMPA was effective in 1986 is when it began. And it really, there were a couple of primary purposes. One was to promote equal sharing of assets and liabilities. So when I married my husband, what's his is mine and what's mine is ours, however the saying goes. So equal sharing of assets and liabilities were in it together. And then at the time, this was in the mid 80s. So there were, at the time, you know, and historically, primarily women that didn't necessarily work outside the home. And there was a goal here to promote availability of credit to a non-wage earning spouse. And again, at the time, that was primarily women. And so there's a provision in the WMPA that we'll talk about that really gets to that. In terms of application of the WMPA, you know, Marcy spent some time talking about the Consumer Act and which types of transaction it's going to apply to. For the purposes of the WMPA, it really doesn't matter. It's going to apply to all forms of credit extended to spouses in any amount. And so really every person on this call and every transaction that you enter into, for every person that's a part of that transaction, you need to consider the WMPA. Of course, if you have an individual, for example, that is unmarried, of course, the WMPA is not going to apply, but it always has to be considered. So it should always be at the forefront of your mind. And one thing I wanted to mention, the WMPA applies to spouses during a marriage. And you have to be in the state of Wisconsin for it to apply. So there's a lot of nuances as to what if you have a decree of legal separation? What if you're legally separated? At what point, you know, are you divorced? If you got married in Washington, D.C. and then moved to Wisconsin, you know, when does the WMPA apply? If one spouse moved to Wisconsin and one stayed in D.C., what does that mean? So every circumstance is different, but I just encourage you to always think about whether the Marital Property Act applies. Okay, so we're going to go through issues at application, issues in evaluation of the credit, and issues at servicing. So there's a few items to point out at every point in time. So the first is just some preliminary items. So at the forefront, we always are concerned about asking about marital status. So as many of you know on this call, inquiries into marital status are prohibited in some respects under Regulation B, the Equal Credit Opportunity Act. In a community property state, which again, Wisconsin it's marital property is a form of community property, you are permitted at any time to ask about marital status. In fact, the only time under Reg B that you cannot ask about marital status is if there's an applicant applying for individual credit in a separate property state. That's the only time you cannot ask about marital status. All the other times are up for grabs. So here, of course, in Wisconsin, you may ask for marital status. So that's great. We need that in order to make a determination of the WMPA. Another key kind of preliminary comment is that you can also obtain a credit report on a non-applicant spouse. So FCRA is, as again, many of you on this call know, a critical component piece of consumer credit. And it's important when you're in a community property state or a marital property act state to think about, well, the spouse. If you have an individual spouse applying for credit, you need to think about that non-applicant spouse, because you have to think about marital property altogether. So preliminarily, you can obtain a credit report on a non-applicant spouse. So let's say I applied for credit individually, and the creditor has the ability to pull credit on my husband. And we'll talk a little bit more about that as to why you probably should pull credit on the non-applicant spouse. And there's a good comment in the FTC's 40 years publication. There was a comment on this that was issued in 1990 on pulling credit on a non-applicant spouse. And I should also invite my colleagues to feel free to jump in at any point in time and correct me or add. The component piece here that is an important disclosure under the WNPA. There's not many disclosures under the WNPA, but one of them has to be provided at application. And this is what we call the marital agreement notice. So in the application, if you have a credit transactions that a credit transaction governed by the Wisconsin Consumer Act that Marcy just talked about, then you have to provide this marital agreement notice. So what the marital agreement notice is basically the creditor telling the consumer, hey, if you have any sort of what we would call like a prenuptial agreement or a marital agreement or some other agreement between you and your spouse, we need to know that before the obligation is incurred, so that we can consider that here. And if you don't provide it to us, basically it doesn't count. And so we need to, it's not going to adversely affect us if you don't tell us about it. So that marital agreement notice, which many of you I'm sure are very familiar with, is going to be considered, it needs to be put in that application. One point on, yes.
Oh, sorry, finish that point. I want to go back to FCRA.
The last point is that it just does not apply. You don't have to provide this disclosure on renewals, extensions, modifications, or open-end credit. So, and I do see we have a question. Marcy, I'm not sure if you want to go back. Okay.
Yes. So first, before we get to that question, we often see in multi-state loan agreements, this notice, this marital agreement notice, that is not the proper place to put it in, it doesn't hurt. It's not harmful, but if that's the only place where it's being given, it won't conform to this requirement of the WNPA. And then secondly, we do have a question on FCRA. The question is, would we have to obtain borrower authorization from the non-applicant spouse in order to pull credit? So in other words, would you have to get consent to give rise to a permissible purpose to access that credit report? And the answer to that is no. So Laura, our PowerPoint cites the FTC interpretation 1990 comment, but that was also brought over into the FCRA 40 years publication by the FTC when they handed the baton off to the CFPB to enforce the Fair Credit Reporting Act. And it expressly states here, and I'm going to quote, not all of it, I'm going to truncate it. A creditor has a permissible purpose to obtain a consumer on an applicant spouse if that spouse will be permitted to obtain, will be permitted to use the account or will be contractually liable upon the account, etc. In addition, a creditor may obtain a consumer report on an applicant's spouse if the applicant resides in a community property state. So it is very clear that you may obtain a credit report of a non-applicant spouse without obtaining the consent from that non-applicant spouse. Several years ago, the question arose as to whether, well, you know, the FTC, FCRA itself refers to community property. Community property is the Wisconsin Marital Property Act, which is the codification of community property principles. Is that considered community property. And the FTC, in its publications and pronouncements on what states are community property states, it always includes Wisconsin. So there's really little question that the WMPA, which is a codification of community property, is considered a community property state.
Awesome. Thanks, Marcy. Yes. So in short, to answer your question, Deanna, you do not have to obtain borrower authorization from the non-applicant spouse to pull credit because you have a permissible purpose under FCRA. Now, remember, you can have a permissible purpose by obtaining the consent or by separately having another distinct permissible purpose, which you do here. So you don't have to. You certainly could. As a belt and suspenders approach, the question becomes, how do you do that, right? If they're a non-applicant spouse, so practically that can present some problems. So it's probably best to just rely on that permissible purpose that you have. Okay, so we've taken the application. Now we have to evaluate the application. So a preliminary comment on that front, and this is also under Regulation B, that you can consider any information about the non-applicant spouse that you consider about the applicant spouse. So remember, we just talked about how you can pull credit under Reg B or under FCRA. And furthermore, under Reg B, I want to point out that there's a provision that says, and it's listed for you here, that a creditor can request any information considering an applicant spouse that may be requested about the applicant if the applicant resides in a community property state. So Reg B recognizes that as well. So you've requested certain credit information, or maybe you've requested certain other information about the non-applicant spouse. Perfectly permissible under Reg B. Then, of course, you say, okay, we've requested it. May we consider it? Now, presumably, if you request it, you can consider it. But we like to, us lawyers like to have proof of that. So under Reg B, that proof comes in 1002.6a, which says that a creditor may consider any information obtained so long as that information is not used to discriminate against an applicant on a prohibited basis. So you can request it and you can consider it. So preliminary, that was the preliminary comment. Now we get into some complicated WMPA stuff. I'm going to tee this up, and I hope that I'm articulate in doing so, but this one can always pose some problems. So if you have a family purpose obligation, now I'm going to pause there. Every obligation under the marital property, under Wisconsin law, if you have a spouse involved, is presumed to be a family purpose obligation. That is a rebuttable presumption under the WMPA. You can get a, I'm going to miss the word. Marcy, help me. It's not it's not a presumption.
Marital purpose statement. Marital purpose statement?
Yes, and the marital purpose statement gives you a safe harbor, essentially. That's the other word I'm looking for. So you can obtain a marital purpose statement, which is evidence that it is, clear evidence that it is a family purpose obligation, but without a marital purpose statement.
I think it's conclusive evidence, right?
That's what I'm looking for. Yes. Yeah. Conclusive evidence of a family purpose obligation if you obtain a marital purpose statement. If you do not obtain a marital purpose statement, it is presumed to be a family purpose obligation. To be honest, we see you guys do it both ways. Some obtain a marital purpose statement, some do not. Anywho, if you have a family purpose obligation, the creditor must consider all marital property available to satisfy that obligation under the WMPA in the same way that it would evaluate an unmarried applicant. Okay, so what does that mean? So you're thinking about this, you have to consider all the marital property available to satisfy the obligation. Now, I'm married, my husband and I each work jobs. Our income, each of our incomes is considered marital property. each of us would have marital property coming in that's available to satisfy that obligation. So if I go and apply for credit individually without my spouse's income needs to be considered. The purpose of this provision in the WMPA was to ensure that a non-wage earning spouse was able to obtain credit and use their spouse's income to enable, the proper underwriting to enable them to access credit. So, in short, the WMPA, it's not just a may, it requires 766.56 sub 1 requires a creditor to consider the income of a non-applicant spouse. We go back and forth. Hopefully I said that clearly. My friends, please jump in if I didn't. But we go back and forth, and I think it's a debate internally, externally, as to whether or not you also need to consider the liabilities of the non-applicant spouse. And I'm not sure that DFI, because they're not responsible for the Marital Property Act. They don't have the authority, and a court certainly, to my knowledge, hasn't opined on this, as to whether or not you consider the liabilities of the non-applicant spouse. There's very arguably you need to, because that's what you're considering in an underwriting decision when you're evaluating an unmarried applicant, and certainly your liabilities affect what property you can collect under the WMPA. Yeah, but there's arguments to make on the other side too.
The key word is available, the property available. And if you have liabilities, that has to be factored into determining what property is available. That's the argument.
That's the argument. Exactly. And our arguments haven't been tested to my knowledge, but it certainly also just would give you a full picture. I mean, because you think about it, let's think about this in 1985, fulfilling the goals of the drafters of the WMPA. You have a non-wage earning spouse applying for credit. You want to consider the income of the non-applicant spouse, but the creditor is not going to consider those liabilities. Yikes. Anyway, you can see which position I take. So that's a provision that can certainly throw some folks off, and we've advised many creditors on this front in the past. And I do see another question. Thanks, Roy John. Actually, so the question is a non-applicant spouse required to sign the loan application and the loan agreement? So we're actually going to I'm going to hold your question because we're going to get to this in a couple slides. So thanks for reading the end of the novel.
And I just want to comment too. Lauren worked with a gentleman who's very involved in the WMPA's enactment. And then, as I mentioned, Ed Heiser also was involved with the process too. They took different positions when it came to this provision. So it just goes to show that very smart and very knowledgeable people can look at the WMPA and arrive at different conclusions. So we do have a lot of clients come to us just very confused about the WMPA, and it's not just you.
Yes. Thanks, Marcy. Okay, so Roy John, I promised we would get here, and here we are. So we're going to talk about signing. Let me first address your question because it's not here on signing the application. Does a non-applicant spouse need to sign the application? No. The answer is no. There would be no requirement for the non-applicant spouse to sign the application. They are not an applicant under the WMPA, under Reg B that I would be aware of. And certainly you've got the individual spouse applying for the credit. So the answer would be no. Now, of course, there's certain obligations that they have with respect to the security agreements, which we're going to talk about in just a second. So let's talk, though, first about signing the note. So actually the WMPA, although this is that presentation, what really governs here is Regulation B and not the WMPA. So signing the note. Let me first say this. There is nothing that would require a non-applicant spouse to sign the note under Wisconsin law. The note should be signed by the applicant spouse and not the non-applicant spouse. Of course, just kind of going back to Reg B, if you do have joint applicants, if my husband and I were applying for credit together jointly and we signed that Reg B intent to be joint, we would both be signing the application, of course. We are both joint applicants. However, if you have one spouse apply, if the applicant, let's say I applied, I'm qualified, the creditor cannot require the signature of the non-applicant spouse. We just kind of went over that. So no non-applicant spouse signature required. If I'm not qualified, let's say I don't quite meet those your requirements, the creditor can require a co-signer or a guarantor or some other form of additional support. But importantly, you cannot require that party be the non-applicant spouse. So you can't require that it be my husband. So there's protections in Reg B against that. So that's for the note. Now let's talk about the security agreement. So we're going to break it up between mortgages and non-mortgages. And I'm going to speed through this a little bit. You guys have got this in writing. So for non-mortgages, signing the security agreement, you're getting the title holder signature. So one spouse holds title, you got to get the title holder signature. If the property is untitled, either spouse can sign. Spouses under the WMPA each spouse has 100% management and control of marital property. So I can put up my husband's and my property as collateral, our marital property. We'll talk a little bit about mortgage. Marital property held in the name of both spouses, so Lauren and Christian Capitini, we both have to sign. Marital property held in the name of both spouses in the alternative, Lauren or Christian Capitini, either of us can sign. Signing the mortgage, I'm just going to say the general rule. And the general rule is the spouse in title has to execute the mortgage. The spouse in title may execute a mortgage. However, if you have homestead property that you're dealing with, and the homestead property is homestead of either or both of the spouses, you must obtain the signature of both spouses, unless we're talking about a purchase money mortgage. So if you don't follow this rule, if you don't obtain both spouses when required, so let's say I have homestead property, my husband doesn't live there, and he goes and seeks to take a mortgage on our home, then the creditor has to come get my signature. If you do not, there's a case that came out in 2017 that says the mortgage is void and cannot be enforced against either spouse. So the penalties are severe. So we have to make sure we get that right.
Lauren,
yeah.
I just want to go back to the whole notion of signing the security agreement and like marital property, who has control and management of it. The whole premise of the Wisconsin Marital Property Act is that each spouse has 100% management and control of marital property. And all property between spouses is presumed to be marital property. So the idea is that I can go to a lender and I can take out a loan individually, but I have control and management of all of our marital property assets and liabilities. Like I don't need my husband to come in and also say, yes, like I have control and management over this property too. So I need to be a part of this transaction. So the whole idea behind the WMPA is that each spouse has 100% management and control. This varies from like a tenancy by the entirety state, where each spouse has 50% of management and control of the property, and you need to get a lot more consent, have a lot more interaction from the spouse.
Yeah, thanks, Marcy. Very helpful. Marital property is so fun. Okay, the last thing I'll talk about is the servicing aspect. So there's one important component piece that always we get questions on all the time, and it's called the tattletale notice. We love this one because it's truly, if you have one spouse that's applying for credit, you have to go tattle to the non-applicant spouse and say, hey, guess what? Your spouse just applied for credit. We just wanted you to know. So if this tattletale notice is only required to be sent if it's, again, family purpose governed by the Consumer Act, which we talked about earlier, and it must be provided before any payment is due. You have a couple options. You can provide a notice that briefly describes the credit, like the amount, the type, etc., or provide a copy of the document evidencing the obligation to pay. I think typically we see a short notice on it. Notice is given the date mailed. It has to be mailed to the address of the non-applicant spouse. And we have taken the position that emailing versus mailing is quite all right. And it is okay under the WMPA. It is consistent with Wisconsin's UADA, so the Electronic Transactions Act. And furthermore, there's no need to comply with the provisions of e-sign, the Electronic Signature Act, because a non-applicant spouse is not party to that transaction. So if any of you have questions on this, happy to address them, but wanted to point that out. And I think Marcy might have one more thing.
Yeah, just one caveat to that. E-sign applies to the extent that you have to get the applicant to agree to e-sign, right? But it's the non-applicant that you do not need to get e-sign consent from the non-applicant. Wisconsin DFI disagrees with that. They take a different position, but the DFI has also admitted and agrees that it does not administer the Marital Property Act.
Right. Lauren, there's another question. It says under the MPA, if the loan is consummated in another state, but the customer resides in Wisconsin, all the MPA requirements still apply? Do they?
Ooh, good question. So I'm pulling out my book. How about we do this? As I'm going to find the answer, but I don't want to spend the time to do it with Natalia waiting. So I'm going to turn it over to Natalia, and Stephanie will come back to your question.
Yeah, and actually,
unless Marcy can answer it off the top.
Yeah, I think I can. So it applies during marriage, and during marriage is the period in which both spouses, Stephanie, so both spouses are domiciled in this state. And it begins when you are married and ends at dissolution or the death of a spouse. So if both spouses are domiciled, to apply. So in your example, if one spouse goes outside of Wisconsin, visits some friend or family somewhere else, it still applies to the extent that the person is domiciled, both spouses are domiciled in the state of Wisconsin.
So Marcy, even if the loan is consummated outside of Wisconsin, yeah, that was my gut too.
Yep, that's right.
Okay, Natalia, take it away.
Thanks, Lauren. Hi, everyone. Thanks for being here today. My name is Natalia Cruz, and I'm going to be really quick, but we're going to kind of switch gears a little bit and talk about two items that you may already include in your credit agreements, or if you don't, you might want to consider after this, and some related issues just quickly. And those are jury waivers and arbitration agreements. And we're mostly going to focus on arbitration agreements, but first, wanted to touch briefly on jury waivers. So just like an arbitration agreement, lenders or creditors can choose to include a jury waiver in the underlying agreement. And jury trial waivers are enforceable in consumer credit agreements. So we have a case here that was decided by the Wisconsin Supreme Court, and this was fairly recently, and the Supreme Court held that and reiterated that the right to a jury can be waived by contract. So this case was Parsons versus Associated Bank, and involved a construction loan that included a jury waiver. And about 2 years into the case, the defendant invoked the jury trial waiver and moved to strike the jury demand. And the Wisconsin Supreme Court reiterated that the constitutional right to a jury trial can be waived, and then determined that whether the plaintiff's agreed to the jury trial waiver is resolved by general contract law principles. So here it found that based on this commercial contract and there was a sophisticated borrower involved in the transaction, who understood all the provisions in the contract, that for these reasons, the jury waiver provision in the contract was enforceable. And that's the general principle for with jury waivers. So with that in mind, we can switch gears a bit with arbitration agreements. So again, parties can agree to arbitration in consumer loan contracts or consumer credit agreements, but the parties have to agree to arbitration in order to enforce arbitration in the case. So obviously an agreement would require the meeting of the minds. And so we suggest, and really the arbitration agreement should be very conspicuous, very clear. So there's no question that the consumer agreed to arbitration in the underlying contract. When the parties have entered into an arbitration agreement, the agreements are presumed valid and are enforced generally under principles of contract law generally. So similar to the jury trial waiver. And then if a court were to deny or grant a motion to compel arbitration under an arbitration agreement, that order is immediately appealable. So just wanted to mention that briefly. So arbitration agreements can include a class action waiver, which would require individual arbitration. And in fact, that's one of the main benefits of an arbitration agreement. It can also carve out the ability to proceed in small claims court. So you can preserve the right to proceed with a collection action or allow the customer to sue in small claims if it meets the jurisdictional requirements. And then also just wanted to note that a court's role in determining whether parties have agreed to arbitrate in a dispute is really just limited to that. Have the parties agreed that this dispute is arbitrable? And if the answer is yes, then it should be moved to arbitration, where the arbitrator could address any other issues related to waiver or delay or any other defenses related to that. So we included a number of Supreme Court cases here for your reading pleasure. I'll touch on the most recent one briefly, and that's Morgan versus Sundance. And here the Supreme Court decided just in May that it resolved the circuit split on waiver and held that federal courts cannot adopt a different arbitration specific standard for waiver. So here the Supreme Court adopted the minority view of the federal courts, and that included the Seventh Circuit, that arbitration waiver cannot include any additional requirements such as prejudice. So this was a very recent case and one that we expect will probably trickle down to the state courts eventually. And then quickly, some other Wisconsin courts cases for your review when you have time. And then obviously reach out to any of us with any questions about arbitration or jury waiver, because I know we went through that really fast. But I want to hand it over to Lisa for the last couple questions. But before I do that, we have two more poll questions. So the first one, true or false?
I think, Natalia, let's just skip these and hand it back to, or hand it to Lisa.
Okay. Lisa, I think you're on mute.
Oh, very good. I thought the CLE, the questions were required for CLE credits in some states just to make sure you're there, kind of like to make sure you're not cheating and leaving your computer running while you're off doing something else. So hopefully you get credit in case you're in one of the, Wisconsin, I don't think is one of those states if you're trying to get CLE credits. But very briefly, I will speak at the next program prolifically on collections and loan servicing, because one of the cases Marcy mentioned, I've argued in front of the Wisconsin Supreme Court 5 times in the last 11 years. And my most favorite one, which I told the justice who wrote it in June at the State Bar Convention, Chief Justice Ziegler, is a case relating to the Wisconsin Consumer Act and the issue of notice of right to cure and what happens when you don't properly give one. So that exciting topic will be covered at the next program. But to briefly refer to these slides on note, security, interest, and lien priority. Oh, and I'm Lisa Lawless. I don't think I mentioned. That's my real name. My husband's last name is Lawless, and that's how I became Lawless. It's been litigated in court in Wisconsin, primarily in mortgage foreclosure actions when there's been a lot of litigation, contested foreclosures in the earlier, a few years ago, where the note is negotiable. It may be enforced by the holder. And the holder includes a person in possession of the negotiable instrument that is payable to the bearer. The bearer includes a person who is in possession of an instrument endorsed in blank. One of the issues that had come up in court when you had contested foreclosures over the years is just proving that the lender, that the party in court has the right to enforce the note. And the Wisconsin Supreme Court held that a court may admit a copy of an original wet ink note based upon the court's own inspection of the original note and its self-authentication, that you have a witness testifying with knowledge as to his or her knowledge that, yes, this is the original note. Sometimes it could have a label on it with a scan that shows that this is the original from your vault. Sometimes they can see that it's actually the wet ink signature themselves. We've had this come up before, but proof of the chain of custody of a note from one servicer to another is not required. And that's fortunate because, sometimes notes servicing changes hands many times. If you don't have a written assignment of a mortgage, that's no problem. Under the doctrine of equitable assignment, a mortgage is automatically assigned to the person in possession of the original note. So the transfer of the note from lender A to the subsequent lender carries with it the security and the ability to enforce the mortgage under the doctrine of equitable assignment. Another concept, these are just refreshers or maybe something you don't deal with in your business, but is equitable subrogation. When a mortgage lender pays off the loan of the prior lender, such as when someone refinances, that lender is equitably subrogated to the mortgage that its loan paid off. It steps into the shoes of the prior lender whose loan it pays off, so long as the prior mortgage was valid. If you file your mortgage in the wrong county, then you're out of luck as to subsequent purchasers in good faith for value who wouldn't know that the mortgage exists if you file it in the wrong county. So lenders who have mortgages need to make sure they file it in the proper county where the mortgage property is located, which makes sense. There's an interesting case about possessory liens, the battle lien priority as between a possessory lien and cattle by a pasturing landowner who's pasturing someone else's cattle and having a possessory lien because they didn't pay off their pasturing fees versus vis-a-vis a lender to the cattle owners who took a security interest, or the cattle is collateral for their loan. And the case Premier Community Bank versus Shoe from 2010 holds that the lien of the pasturing landowner has priority over a perfected security interest in the collateral, in the cattle as collateral. The lien is possessory. We worked on a case where we did an amicus brief for a trade association, and the issue is an interesting one. I just want to point out, sorry, I'm popping back and forth, is the issue of subordination. In this case, a lender extended a note, paid off a prior loan, got a subordination agreement with a junior lender that was prior in time, but behind the original first mortgage. They got a subordination agreement that agreed that the junior lenders or the junior lien holders lien was subordinate. However, the agreement only said for this particular note. It didn't say it's subordinate to this particular note and a future extensions of credit. However, the lender had extended the first note, note one, and its mortgage secures future extensions of credit. So in the future, after entering into the subordination agreement, it had a second note. However, its subordination agreement didn't check off that subsequent extensions of credit were also had first priority over the junior lien holder. And this was a case that was litigated and contested at the time of a sheriff's sale, and the junior lien holder came in and contested the right of the number 2 note to stand in front of its junior lien. And the Wisconsin Court of Appeals held that the first note has priority over the junior lien holder, but the second note does not, because the box was not checked off on the subordination agreement that it subordinates to future extensions. That case also involved the issue of a credit bid at the sheriff's sale, and the court held that the credit bid was for note 1 plus note, or a little bit less than note 1 plus note 2, but more than the amount of note 1. And the court held that the credit bid was invalid because it was higher than the amount due and owing under note 1. That is all I have on mortgage priority, subordination, security agreements, and liens. And we want to open it up to see if there's any questions over any of our topics or anything else.
I think since we're past time, if you have any questions, please feel free to email us or give any of us a call, and we'd be happy to talk through any questions that you have. But we can close and conclude the webinar. Just as a reminder, a few points. This program has been approved for legal education hours, so click on the CEU icon at the bottom of the screen. We will send you a certificate of attendance, including course numbers, tomorrow, along with a recording, so you can go back and listen to our great presentation. And then please be sure to complete the short survey. We really appreciate your feedback. And we're really grateful that you attended. Thanks to Lisa, Lauren, and Natalia, and Emily Schumacher, who helped put this all together. Our next presentation is November 30th. At noon, and we'll be picking up on loan enforcement and liabilities in collecting against consumer credit transactions. So thanks again, and have a great day.